Hello, I'm Heidi Myers, immigration attorney, and today we are going to talk about what happens if the U.S. Supreme Court issues a decision that ends up terminating DACA, Deferred Action for Childhood Arrivals, or what is known as the relief for dreamers that gives dreamers work authorization and allows them to stay here. Now, if your DACA is terminated and you've never been put in removal proceedings, ICE cannot just arrest you and put you on an airplane and deport you. No. ICE or DHS first has to issue a notice to appear, which is the initiating document for referral into removal proceedings. You will have several hearings in front of the immigration judge where you can present any of your arguments about why you should be allowed to stay in the United States, whether or not you're eligible for the green card or any other relief from removal, such as cancellation of removal or any sorts of other waivers, perhaps asylum, withholding under the Convention Against Torture. Even if you lose at the immigration court level, you then have the right to appeal to the Board of Immigration Appeals. The Board of Immigration Appeals is part of the U.S. Department of Justice, and even if your appeal at the Board of Immigration Appeals is denied, you have a second level of appeal to the federal courts of appeals. For example, if your case was here in New York Immigration Court, you would have an appeal to the Second Circuit Court of Appeals. If your case was in New Jersey Immigration Court in Newark, you would have an appeal to the Third Circuit Court of Appeals, or supposing the Houston Immigration Court denied your applications for relief from removal, you would have the Fifth Circuit Court of Appeals, assuming you were already denied at the lower appellate level with the Board of Immigration Appeals. So it is a long process to deport someone. There's no reason to panic if you lose your DACA and your work authorization. You have some time to get together your documents, to present whatever your arguments are, if you're eligible for your green card or other relief from removal. So number one is don't panic if the Supreme Court ends DACA. You still have time to present applications. Now, different people will be in different situations. For example, certain of the DACA dreamers have never been in any removal proceedings at all. So they might be walking around, going to work, going to school, doing whatever they normally do until ICE gets around or DHS gets around to issuing a notice to appear for them to appear in immigration court. So those people have the most time. The second group of people are those who were in removal proceedings and who had their removal proceedings administratively closed. In that case, ICE would have to file a motion with the court to recalendar removal proceedings. And again, you'd have to go back to court for at least 2 court appearances, one master calendar and at least one more court appearance where you would have a hearing on your applications for relief from removal. The other group of people would be those who already have outstanding removal orders. Now, yes, people who received DACA, some of them already had removal orders. In that case, you may be eligible for a waiver of your old deportation order. There's what's called the I-212, and supposing you have an approved family petition through your spouse, through some other family member, you can present a waiver to USCIS, and USCIS would look at the positive factors in your case, that you've been living here since you were a small child, how many years you've been here, if you have a solid work history, paying your taxes, all your good qualities, how important you are to your spouse, your U.S. citizen children, your community, and then they would balance that against whatever negative factors there are. Aside from the removal order, did you ever fail to appear? Are there any other negative factors in your case? So you could get a waiver of your old removal order, and then if you have an approved relative petition or some other petition, you can then get an unlawful presence waiver if you have a U.S. citizen or permanent resident, spouse, or parent. So the point is, don't panic. If the Supreme Court terminates DACA and you lose your DACA, no, you cannot be put on a plane immediately and deported. It's a whole long process. Even those who have outstanding removal orders, it's going to take time for ICE to find those people, to get travel documents. In the meantime, you could possibly file a waiver. You might be eligible for other relief. You might be eligible for relief under the Convention Against Torture. So don't worry. Well, I'm not saying don't worry, but don't panic. Panic does not help anything. Use your head. All right. Now, each person's situation is very particular. A lot of you have been living here for many years and have your own individual circumstances, so you really need to talk to a good immigration attorney to know what your options are and what you should start doing now. You can contact me, Heidi Myers, HEIDIMEYERS. I'm at 11 Broadway, Suite 925, New York, New York, 212-791-4007 or 646-508-5225. My email is HeidiMyersLaw@gmail.com. HEIDIMEYERS law@gmail.com. And if you like this video, please give it a like. Thank you very much, and I hope to see you again soon.